Welcome, everyone, to the first FSBPT Regulatory Hour for 2026. My name is Dave Relling, and I'm president of the FSBPT Board of Directors, and we're thankful to have all of you here this afternoon. FSBPT continues to utilize regular webinars like today to provide educational content on key issues impacting regulation and to provide foundationally important content on the role of regulators through these regulatory hour webinars. The FSBPT board recognizes the challenges facing regulators. We want to hear from you and understand your jurisdiction specific concerns and how we can help at FSBPT. If there's anything that I can do or to help connect you with another board member or staff member to help address an issue, please feel free to reach out to me. Today, we're excited to have Dale Atkinson back for another regulatory hour. Dale's topic is conflict of interest. Dale will walk us through the challenges to identify, manage, and prevent conflicts of interest in our board and committee work. And with him is Margot Adams Larson, a psychologist at the University of North Dakota as an adjunct faculty member, and then also a psychologist within the city. Questions can be submitted in the chat function during the presentation. Please remember that we are in a virtual meeting, so mute your microphone unless you want to speak to the group. And with that, I'll turn it over to Dale and Margot, and thank you so both for being here today.
Thank you, Dave, for that introduction. And I will give my welcome to the first meeting of 2026 webinar. And I want to start off by saying thank you to multiple folks. And first off is Dave, you and your board of directors at FSBPT for the important work that you do in that volunteer role of operating the FSBPT. A big shout out thanks to the staff of FSBPT, Jeff and you and the team for what you do to again put these webinars together, as well as all the other programmatic issues that are addressed. But the biggest thanks also goes to all the attendees today, no matter what role you play, whether you're a regulator, appointed by the governor, sitting on the board, an administrator, executive director, an inspector, an assistant AG, whatever role it is you play, it's really important. You're not thanked enough, and I will reach out and say thank you now for the work that you do. I'm Dale Atkinson, and I am general counsel to many organizations that operate just like FSBPT, and I have provided legal services to my clients for almost 40 years now, all in the world of nonprofit organizations just like FSBPT. So I'm hoping that experience brings some information that's of relevance to you all, and that you have some take-home points when we're finished today. I am joined by, as mentioned, Dr. Margot Adams Larson. She'll introduce herself in a moment, but we will address today's conflict of interest topic without slides. This is the first time I've done this in the form of a podcast format, conversational format. So we look forward to your remarks about how this works, one. Two is we encourage you to use the chat feature, as has been mentioned. And if you have something to say and you want to unmute, please feel free to do that and speak up. Conversations are the way, I think, for adult learning to be most effective. So Jeff and the staff, if you'll keep an eye on either raised hands or even chats, and feel free to interrupt Margot and I as we move forward. So Margot, I will turn this over to you to introduce yourself, and let's get us started in the podcast today.
All right. Well, welcome everyone. I am so grateful you are all here, and I am grateful to be here. This is a passion conversation that I enjoy. And as Dave and Dale both mentioned, I am a licensed psychologist in North Dakota and in Utah. I provide leadership coordination services for the Atkinson firm. I do a ton of speaking in the regulatory world because I didn't run fast enough in North Dakota and was on the board of psychology there for over 13 years, many of those serving as president. So I come with some wealth from the trenches, and I know many of you are in the trenches. So I just want to say a great big thank you because we don't hear that enough. Today's conversation is really intentionally focused without slides because of the nature of conflicts. It's easy to get lost in the education and the kind of the slide production, and we really want you to be engaged in this conversation. So please feel free to post in the chat, to raise your hand if you have questions or ideas that you want to bring or curiosities to this conversation. This really is the essence of how to navigate conflicts in any realm of our world, but we're going to focus today on that regulatory board and the conflicts that arise in our well-paid, high-paying positions as regulatory board members. And what I would love for you all to do, just as we're getting started, is to think of a conflict that may have come up or you thought might have been a conflict in your regulatory role. Maybe it's yours, maybe it's someone else's, but just kind of conjure up what that means for you or what comes to mind. And we'll be touching on these points as we go along in this conversation. I think the first question that I have for you, Dale, is what is a conflict? Just a plain old conflict.
Well, that's an interesting question, especially in light of the topic. And it's sometimes, I think, hard for me to decide without diving deeper into conflict of interest. But I suppose conflict is individuals disagreeing with one another. And that can be done, I suppose, in a positive or perhaps negative way. But, maybe that's why I start out thinking about conflict.
And I think it is a question that a lot of people sometimes will say, well, you know it when you see it, but it's hard to describe, or it's easier to describe, but you don't always know if what you're seeing is a conflict. And I think by nature, humans tend to want to avoid conflict. We don't want to upset someone. We don't want to have an uncomfortable conversation. And oftentimes, those are some of the things that we associate with conflict. And I think you mentioned something really interesting, and that is there's two opposing positions. And sometimes in conflict, there can be even more perspectives on that. It's not just one or the other. And I think sometimes in avoiding any conversations about conflict, we end up just ignoring it altogether. And that's what we're here hoping to encourage you all to have more conversation and curious discussions about conflicts. I think the next question I'd like to toss back to you, Dale, is what's a conflict of interest? Because you did mention that, and I'm curious if there's a difference.
Yeah, I think that's an important aspect to identify conflict, which might be differing views, which might lead to productive discourse in your board meetings, as opposed to or in conjunction with conflict of interest, which I think is more of a personal driven issue that reflects your ability or perhaps inability to be objective on a matter that comes before the board. And very different concepts, conflict or conflict of interest, but important to distinguish between those two. But I think it's a lack of objectivity in the decision-making process of a regulatory board.
And that comes from lots of different places, and we'll get into that in a little bit. But I think one of the things that in my world of, being a past president and having a lot of discussions in terms of spotlight board meetings, those kinds of things, I think sometimes conflicts can make us feel uncomfortable and that we're not sure when or how to address it, maybe, or what words to use to bring it up or call it out. And I think that's a really important component and consideration of what you mentioned in terms of conflicts of interest related to our regulatory board service, because even though they're uncomfortable, would you say we need to address them?
Sure. And I think the reason it makes it, in my mind at least, why it's uncomfortable is it brings the spotlight onto you.
Uh,
And you are going to have to either potentially identify an issue. And I think we'll get into this later a little bit, but you don't have to, with specifics, identify issues when conflicts arise. You have to identify the lack of objectivity in the decision-making process. But I think the uncomfortableness is one, it might feel like it's conflict. The first conflict we talked about without the of interest side, which there's an uncomfortable feeling with that. But two is it's a spotlight on you then to say, can you remain in this regulatory board decision-making process, or must you recuse somehow or step aside for at least that particular matter before the board right then. So I think it's that spotlight issue that probably brings most of this discomfort. And I'd be curious to any of the attendees to put anything in the chat or unmute about your uncomfortableness with either discussing this issue or if it's related to something that you feel you need to recuse from, how that might come into play. But an important point, I think, to the regulatory board effectively and efficiently operating as a team.
I think sometimes from our heart of service or volunteerism, we don't want to let our board members down or others down. And so it may also be trying to make it through and help out as much as we can, even though once we have that sense of a conflict or that identification of a conflict, it's really important to have some discussion and conversation around how we can mitigate that. And I think that begs the question of, are all conflicts of interest problematic?
I think clearly the answer to that is no. And I think this is a good point to bring up early on, and we might emphasize it later. And that is, as a lawyer, if I'm representing a respondent in front of your board, I can probably create a conflict out of just about any situation that's brought forth. So now, is every conflict of interest problematic? Those that affect the objectivity of the decision-making process, yes, but not all of them do. And so there will be times when a board member may wish to identify what might be perceived as a conflict, or perhaps it is an actual conflict, but identify it into the record and continue in the decision-making process. You do that for a couple of reasons. One is to make it of record. Two is you're probably trying to foreclose the defense lawyer's argument that there is a conflict and that the matter was unjustly or inappropriately decided by the board itself. But, to the heart of your question, are they all problematic? By nature of the phrase conflict of interest, it might feel that way, but board members and staff of boards do not be persuaded or intimidated by the fact that conflict of interest is brought up, because it's important to talk about it. It's important to identify it. And it's really important, I think, to communicate about it.
And I agree with everything you've said. I think the conflicting perspective I would offer here is that if a conflict is not identified or brought up or discussed or, had some resolution, any of those kind of conflicts are going to be problematic. And that's really the area and zone that's going to contribute to either immediate discomfort or difficulty in the board making decisions or some long-term ramifications in terms of the legal defensibility of some of those decisions. So, I think really important to recognize the importance of discussing and having conversations about anything that's perceived as a conflict to help navigate that process for the board.
And if I may, there's a chat that's been asked, and
Yeah.
let's address that. It says, I will retire my PT license this December. So I'm assuming we have a licensee who then will no longer be a licensee. And remember, as you retire, give up a license, the knowledge doesn't go away. So it's still there, but let's continue on. So I'll retire the PT license. I have applied as the public member of the Kansas Board of Healing Arts. It's an umbrella board with an opening next year. Is there a conflict there? I think that's a two-part question. I would start, are you truly a public member? So the first real question to answer, it's a little bit off topic, but this is worthy, because it's been asked. The real question is do you qualify as a public member? as a former licensee, especially as recently as this year, 2026. So that's the first place where you're going to the first issue you're going to have to address by reading the statute and the definition of a public member. Um, and then secondly, now is there a conflict? So I'm not sure I would see a conflict in a former licensee seeking to become a public member, assuming the statute allows that. I don't know if I see a conflict because you're no longer holding a license, but I could see some problems arising. Well, let me not use problems. I could see issues arising out of this question, and the importance of it. So, one, thank you for putting it in there, and everyone else, please keep those chats going. But that's a really interesting question from the standpoint of qualifying as a public member. Probably more importantly, if you will, than the question of conflicts.
And I think this really illustrates actually a component of the importance of conversation around, is there a conflict? Even just asking the question. And the information provided doesn't say, well, this person owns a business that might employ people of the healing arts. If we get into that, we may be getting into some conflict. So on the surface, the information that we gather on the initial question, when we're talking about conflicts, also often needs to have much deeper conversation and curiosity around why the question's being asked and what the circumstances are. So I appreciate both the question and the opportunity to address that. That circles back to one of the things that I feel is one of the most important considerations, whether we're talking about leadership roles on the board or whether we're talking about how the board is functioning and the agenda items that are coming before it. The most important ingredient in my mind of assessing conflicts is the discussion around what's going on. And that requires knowing and some education components about conflicts, but it also requires being open to feeling a bit uncomfortable in having some of those operating perspective conversations, meaning that we all bring different seats, different learning histories, different experiences in careers and life to the table. And that's what is the value of having a board composed of many people. But it's also the challenge when we're talking about, differences of perspectives and opinions. Dale, there's a number of different ways we can kind of categorize conflicts of interest. And I'm wondering if you could walk us through a few of those.
Sure, and I want to go back to quickly your point just about the communication and not over address it, but the question that we just got about giving up a license and then becoming a public member is a communication issue. And so I agree with you. This is great. Ask the question, regardless of what the answer might end up being, get the information out, make the so-called right decision and carry on with confidence. And so, to your question about the types of conflicts, they can come in many forms. And I want to start by talking about actual perceived or potential conflicts that exist. And so not everything we talk about is going to be so easily, one, categorized or two, identified. So you could have a financial interest in a decision-making process made by your board. And we'll come up with a few examples, I think, later a bit. So I'll throw out at least some of these terms and we'll dive into them a little deeper, as we go along here. But financial, it could be monetarily driven that you're accused of you're benefiting from a matter based upon a decision making that is undertaken by your regulatory board. So it could be money driven, financial driven, benefit. It could benefit a business. It doesn't always have to be just financial. It could be personal, relationship driven, based on knowledge, knowing someone, a former student, your best friend, your worst enemy, your spouse. It could be driven by your knowledge of an organizational structure or a corporate structure that exists that you may be involved with, or you may be involved in working for, but it's far enough removed so that then might be perceived as a conflict. Misuse of information. You could have a conflict based upon a matter that is before the board, an adverse action or an investigation, assuming you play a role in that, either decision making or investigations, and you are out on your own doing your own research and Googling the respondent or the complainant, if you know who that is. So it can arise in so many aspects. It's hard to just pigeonhole them all, but you need to understand it. Probably the most important part about this conversation right now is that you understand the philosophical concept of conflict of interest and that it can be identified so that you can seek advice and guidance either through counsel, executive director, or whomever it is that's properly identified. And then, as I said earlier, you can then reflect upon that and react and act as needed to protect the integrity of the regulatory process. So there's a host of potential conflicts, but keep in mind it doesn't always have to be actual. Perceived conflict may be enough, but again, that's subject to interpretation.
Well, and I'm glad you emphasized that, as I think most jurisdictions have prospective board members, even the person in the chat said they applied to be a member, and there is some rigorous reporting and accountable considerations that you have to report on the applications for a board member position. How all of that plays out and how it's evaluated or interviewed through governor's office or whoever's doing the appointing is a whole different process. But that doesn't mean these things won't still come up in the course of what we do. And I appreciate your conversation around the perceived, the optics of how a conflict may be seen, even if it's not actual. That perception or optics of a conflict may be enough to have an influence in terms of how others view the decisions of the board or how the board members are making decisions. And, you know, you all may be feeling at this point like, oh my goodness, now what? Like, how do we resolve all of these things? Because this is the uncomfortable part now that we know, now we really can do something about it. And I think that really is the secondary component and why having this conversation is so important in learning some language of how to navigate. Oh my gosh, I just recognized this applicant. I didn't know that that's who they were when I was reviewing their stuff. Now, what do I do? What words do I use to convey this? And so, management of conflicts to me kind of resides in a few things. It resides in education, and Dale's emphasized this, and it can't be emphasized enough to understand the theoretical underpinning of what conflict means, to be able then to disclose and to share with others. And ideally, that's maybe your legal counsel, but it's probably a most protected conversation. Um, and then figuring out what might be the best approach to navigate. It doesn't mean you get kicked off the board. It doesn't mean that you can't still help and serve in your role, but it does mean you may have to do a few things differently, that you may have to recuse from certain discussions and decisions. And now's a great time to really talk about kind of what does recusal mean. And I'm going to step back one more space to say your board might best have some policies and procedures around this, because the clearer those are, the easier it is to navigate when these kinds of things come up. And most commonly, folks will say, oh, I'm recusing from this item, but they stay present in the meeting and they don't leave. And, they may even chime in, and that becomes continued conflict and continued influence potentially with the board. So I think thinking through what are some of the things that we can do, who can we seek for advice? And Dale, I know you have some ideas on that, so I'll toss this question to you. Ideally, who do we talk to?
And
And
maybe Marco and Dale, you have
okay.
another comment in
Yeah,
the
I
chat.
see those. Yeah,
You got those? Yeah,
yeah,
maybe because those kind of fit with your previous conversation about like what do I do, where do I go, who makes this decision prior to before moving on to some of the specifics of what recusal might be and what you're supposed to do with those. Those seems like these two are still with the decision making process. So maybe if you want to address those.
sure. And I might even just quickly take a step back to about that perceived conflict issue. Remember that your legislators watch your boards and they may know less than they think they know about what regulatory boards do, but there's perceived conflicts about what some might describe as self-regulation. It's a bunch of licensees with a public member or two sitting around representing, if you will, or I should say regulating other licensees, and that in and of itself might be perceived by some legislators as a conflict. So just don't forget that perspective as I move to these comments that or chats that have been made as well. So this one's kind of long, and so let me just kind of zip through it to get the issue out onto the table. But a board's considering a request for reinstatement of a lapsed license for a person who has current restrictions on their license in a different state. So what's important about that is you know about what's going on in another state. So the person either self-disclosed or you have data banks and others, and including the what is the Jeff, you can unmute and tell me.
E ELDD, Exam
ELDD.
Licensure
Okay.
Disciplinary
Yeah.
Database.
So
Yep.
so it's so there's a first point. Carrying on with the chat here, those restrictions are about to be resolved in that other state. So I'd stop there and say, how do you know that? But maybe it's the now reinstating seeking person tells you that. Okay, great, fair enough. But the PT is considering moving back to the original state. One of the board members has worked with this person. So now here we're getting really close to this potential conflict question, certainly in your state. One of the board members worked with this person as his knowledge of challenging behavior. Okay, what happened? When they were originally licensed in the state previously. Wow. So this is a deep, we could make a little exam out of this question, by the way, and have you all try to decipher the issues and then answer them. But when they were originally licensed in the state previously. So a board member in state A has now a lot of knowledge about practitioner when they were licensed in state B. That's an interesting concept as well. That board member believed they had a conflict of interest and recused themselves from voting on that particular reinstatement request. Probably the right move. From your perspective, was that the correct action to take? And was there a true conflict? I think the answer is probably yes. There's too much other information in my interpretation of what you wrote here by the board member that is outside the realm of the formal record that you use to make this decision. Let's reinstate, let's not reinstate, especially if it's let's not reinstate. And this board member is throwing in a lot of information that is probably questionable whether it would be whether it would be admissible in a formal hearing or anything else that might be had in this reinstatement or seeking licensure, et cetera. So I hope that didn't get too confusing for folks, but you all can read the chats too, right? I think you can see them, so you can see the issues that are coming out of this. A lot of issues in this matter, but no, I think recusal is probably the right course of action in this. And the second chat says, how do
Oh,
you discern?
before we go on to the
Yeah.
second one, I want to say there's one more elevated perspective I would add to that question, and that is if this is the board member writing in, that's one thing. If it's another board member writing in, we've got an influence already of information coming through two board members. And
Well
so
done.
there may be two conflicted board members in that scenario. I don't know. I'm just kind of saying there's always more to the story, but I think it's important to recognize where that information is being shared and who has it, and if they might be conflicted now because of that information.
And that's a really good point too, is that if I'm conflicted and I have a lot of information that may or may not be true, it may or may not be admissible if you get to a formal proceeding, and I start throwing that all around, I am probably threatening the objectivity of the rest of the board that's now listening to me. especially if I'm in a position of authority, presiding officer or what have you. So that's a really good point that conflict can be spread, perhaps inadvertently. And it again, this doesn't mean that the sky is falling, but it gives defense lawyers something to argue about. And it gives defense lawyers something to challenge if the decision doesn't go their way on behalf of their client. So,
Before we
really good
get to the
point.
next question, Dale, just on that topic, who then would a board member ask these questions of? Because obviously calling their fellow board members is going to kind of spread the conflict around. Who would be good to talk to?
Yeah, and I think that would be board counsel, and you all have board counsel. It's either through the Attorney General's office, or you may have private counsel. You may have both, by the way, for prosecution versus advising the board. But I think you can reach out to counsel, and you have every right to do that. And to that point, and this is relevant to previous webinars I've done for FSBPT and others, and that is board members shouldn't be talking to other board members in between meetings anyway. So you're not going to ask another board member any question that's relevant to the board meeting, but for, do you want to have lunch, when we meet. So you want to be careful about those types of communications, but ask your lawyers. And by the way, while I'm on that topic, follow the advice of lawyers. Right now, we are here throwing out issues. We are here, identifying relevant facts that might be taken into consideration, especially from that last chat, that longer chat. Follow advice of counsel, but we're happy to weigh in here too. So the next chat is, how do you discern perceived conflict of interest, and does a board member have immunity? Two important questions. Perceived conflicts are difficult. And this is why I might say a matter comes up, I'm on the board. Quickly give you an example. I'm on the board. A respondent is before the board, and we make the decision on guilt or innocence. That respondent was a classmate of mine. Okay, great. We start asking questions. Well, how long ago? It was 25 years ago. Were you close? Oh, we barely talked to each other. We studied together. We were best friends. We were roommates. All of these issues will come into play to ultimately decide whether that conflict, and that would be perceived in my mind, would lead to a recusal or some action or some identification of the record. And this is actually a pretty good example to use to say, I might go on the record under my example and say the respondent was a classmate of mine. It was 25 years ago, and we barely talked to each other. So although there may be a perceived conflict here, I believe I can remain on and in a decision-making capacity in this matter and objectively determine the outcome of this case. So you might read that into the record. And as I said earlier, that does a couple things. It identifies it in the record, but it might foreclose some legal arguments coming down the road into the future of a challenge of that decision. So
I think the important thing there, though, Dale, is it's not just that you perceived this, but that you had a conversation about
true.
it. And that conversation was with someone other than yourself. We are really not great at, we can convince ourselves of all sorts of things, but having another perspective come into that, and ideally somebody that isn't going to also be influenced by that conflict. So the board attorney or someone else to have that conversation with is key.
But I think you had then ultimately asked, what are how do you manage these issues? And, it's understanding, it's identification, it's seeking advice, reflecting, and then taking an action. And generally that action would be either recuse or not recuse. Recuse is you walk away from it, you don't participate, you do not influence. And in my mind, you would leave the room, or at least leave the front table, so you do not look like you're in a position of influence or decision-making authority. You do it on the record as soon as you know about it, but you do not need to use details. You can say, for reasons of objectivity, I'm recusing myself, and that's all you need to say. The record will reflect at 2:34 Mountain Time, I left the meeting, and the board will carry on with its business and take care of that. But disclosure, identification, communication is absolutely key. And the alternative, I've already said it 2 or 3 times, but is I might identify the issue and then say I can remain objective and stay in the matter too. So Those are going to be generally the two, but communication is critical.
And I want to highlight something that you just mentioned in terms of leaving the meeting. And we have a lot of digital meetings where we can put people in the lobby and we know for sure they're not participating or overhearing the information or having a way of influencing those that remain. Being in the room, still to me provides a conflict issue because you may be hearing the meeting then, that you've got more information that maybe could be a misuse in another aspect of what you do, or just your mere presence maybe limiting the conversations that folks are willing to have related to the topic or agenda item. And so, I think all of those things are really important to consider. And again, going back to having a policy or a procedure that's followed can be a great tool to rely on during these times that are bound to come up.
Do everything you possibly can to eliminate an argument that could be made on appeal that might question the process. And I think I think that's a good position posture to take.
And I want to chime in here. One of the slides that you can have access to that I really wanted folks to really think through related to conflicts, and that is uh, conflict of interest management is really simple, but it is not easy. And what I mean by that is it's simple to learn the information, it's simple to apply that, it's simple to have conversations about this, but these are also things that are not easy to do in being that we're all humans and come with different experiences around conflict. But as a past president, one of the kind of rules, so to speak, that I put together was just, going back to the adages of if it walks like a duck, if it talks like a duck, then it is a duck. If you don't see it, but others see it, it's still probably a duck. If you think it might be a duck, then it's also maybe a duck. And if it's an egg that could possibly be a duck egg, then it's probably also a duck, meaning it's not bad that there's a conflict. What's really challenging is if we ignore that and don't have a conversation about it and don't have a process of thinking through it, speaking about it, discussing it, and figuring out a good resolution for it. And I think that kind of ties into the last aspect of the question, Dale, that was asked, and that is, does a board member have immunity in these circumstances? And, kind of where do we fall with that?
Yeah, immunity. I'll go through that quickly. It's probably a great topic, Jeff, for a future webinar, because board members need to be protected. And if you act within the scope of authority, this is the very short version of immunity in the world of government regulation for all of you that are listening in. If you act within the scope of your authority and in good faith, immunity will rise up to protect you. And conflict is actually a pretty good issue to address the immunity principles, meaning if you don't see the conflict, you insist to stay in a decision-making process, you influence the board, that can threaten the immunity principles that do ultimately protect you. But overall, act within the scope of authority and in good faith. And I think, as we roll in our time here, maybe we can do a few examples here and
Yeah.
identify these.
So I guess one of a fairly common experience would be something like this, where a person is serving as president of a state chapter of physical therapy trade association, and they are appointed to the physical therapy regulatory board of that same state. Do we have a conflict?
And I think the answer to that is a pretty clear yes. Now, I want to be cautious too that belonging to the trade, maintaining your licensure status, attending trade meetings, that's very different than being in a position of authority. The president of the state chapter, the president of the national chapter, or other decision-making and or policy-driven positions that might exist. That's where the conflicts might start to rise up. In the example that you identified, perhaps shame on the appointing authority, the governor's office, for even doing that, but it does happen. And in other professions, I know of at least one state where the president of the state chapter of the trade association is by statute automatically on the board. So, these are debatable issues. These have to be addressed. They have to be understood. They have to be discussed, get advice, reflect, as I said, and then act or don't act depending upon the circumstance. But don't be bashful about being a member of the trade association, but if you're in a decision-making authority, I would suggest to you that you have to choose one or the other. You want to be a regulator, great. But if you want to advocate for the trade, that's fine too. And if that means you resign from the board, that's okay. And quite frankly, where I have seen individuals resign from the regulatory board because they want to be advocates, it almost warms my heart. You see the issue, you understand it, and rather than attempting to influence two sides of the equation at the same time, you've chosen one and you carried forth. So always a question that comes up: involvement with the trade association, and where is the line to be drawn? There's no bright line test, by the way, for any of these issues, but that question comes up frequently.
Let's move to an example that's more kind of board specific now. So there's a complaint that comes in against a physical therapist. The physical therapy board finds the potential for imminent harm to the public, and if that physical therapist were to be allowed to continue practicing through investigations. So there's a summarily suspended license occurring. Can the board, that same composition of people, ultimately hear and determine the administrative case when it's ready to be adjudicated?
Yeah, this scenario comes up. I wouldn't say often, but it has come up. It's been litigated, and most of the litigation, all the litigation I know of, falls in favor of the board itself. So the board, and we're making some assumptions, and we know that you all have a different, each of you have a little different process how you might address administrative matters. Or maybe an administrative law judge that makes a recommendation to the board. There may be commissions that make their own decisions related to respondents and complaints. But in some of your boards, you make the decisions as a board as a whole. So the question on the table now is if you've made a decision on a summary suspension or emergency suspension, which, by the way, you have to have that authority in statute. If you're able to do that, imminent harm to the public, you take the license today and you have a hearing tomorrow. That's basically what that means. Is that hearing you have tomorrow, can the same body that summarily suspended make the decision, ultimate decision? It's a really good question. It does create legal debate, and we could have quite a debate if lawyers were on the line and wanted to. I think the answer is yes, the board can ultimately make that decision. There is some litigation that supports that, but it does help us all understand and illustrate how a conflict might arise and unintended consequences might surface out of that. So you may have subcommittees of the board, assuming the statutes allow you, and that might make a summary suspension decision, and that subcommittee then doesn't participate into the future. That's probably the safest way to do it. But there are different versions of how you might try to overcome these potential conflicts. So interesting question.
I think overall, it's a thinking down the road of what could happen. And so as you're considering those conflicts and maybe realizing some practices you've never thought could be or have a conflict, it's now being able to really reevaluate those and see, is there potential conflict down the road that may be argued. Um, I think we've got maybe time for another scenario, and happy to have some more in the chat as well. But here's an example one of a physical therapy board member who is upset with some proposed legislation in their state that's entirely unrelated to physical therapy. And this board member writes a letter to all the legislators and governor expressing their dissatisfaction with the proposed bill. What if any, conflicts arise in that? And would that change at all if the bill were related to physical therapy?
Um, okay, so let's start with the first part of the scenario of a unrelated physical therapy. Um, Board members are individuals. They have First Amendment rights. They have the right to be advocates and to place their positions of record in whatever other way they wish to do that. The writing letters or editorials, whatever it takes. You're not going to lose that by being appointed to a regulatory board, but there may be a time when legislation is close enough to physical therapy practice that it may be perceived or an actual conflict that does surface. And you might, if you will, give up that right to advocate because you are also concurrently serving on a regulatory board. So I could see a situation where legislation might be introduced that does affect physical therapy practice, and that your desire to weigh in and advocate for or against that bill might interfere with your objectivity and decision making of the board. Now, we all know boards speak with one voice. The board may be asked to testify through your executive director and or presiding officer on a bill. And so, that does create the mechanism for a board to be an information source to the legislature. But once we start to separate you all as individuals and decide what can and cannot be said, it becomes a little more difficult question. But I could see a situation where a board member would be, if you will, precluded from taking a position on legislation. But these questions can be quite difficult to decipher unless we have a lot more facts. But our goal here today is propose enough and throw it on the table so we all conceptually understand the issues that might surface.
And I would say related to whatever letters the person may be writing to not identify themselves as a board member when they're writing as a citizen. And I think, while not a specific conflict of interest, it does put the board in a very precarious position when those kinds of things do happen, either to legislators or newspapers, et cetera.
There is
Um,
a matter, if I may, too. It's a Wyoming piece of litigation that I believe has been settled, and I can't find the settlement agreement. But the very short version of it is a member of the medical board of Wyoming did not like legislation and wrote letters as an individual, not as a member of the board. But the position that he took on this had the potential to influence his decision making of basically every licensed physician in Wyoming, because those licensed physicians come to the board to renew their license. So the governor thought that was a conflict, removed this member from the medical board, replaced him, and that removed member sued the governor. And this case is public now, and right now the name is escaping me, so maybe I shouldn't have brought it up, but I can find out and send it to you, Jeff. But the point of all this is that here's an issue where a board member was removed by the governor, the appointing authority, based on conflict principles, and filed a lawsuit. And he's arguing for damages too, by the way, because medical board members in Wyoming get paid pro rata what the elected legislators get paid. So there is a money issue at stake here. The matter has gone away, and I don't know how it was resolved, but we can all use this as a learning point, a learning tool from the standpoint of how these issues might arise. So,
oh,
so
I
it's
thought you meant we should move to Wyoming so we can be paid as
yeah,
a
we can do that
regulatory
too.
board
We know you all are paid so much right now.
Yeah, I think one of the things that always comes to mind in these conversations is, I think, having come from a very small state, there's obvious ways that conflicts arise in terms of board members with past students who are, coming through and getting licensed, and maybe they've been in academia or supervising. And so I think smaller state places, we're used to maybe having and navigating some of these kinds of conflicted positions and roles. And yet, these are all the same conflicts that occur even in larger areas. And I think having um, an understanding that conflict isn't bad unless we're not talking about it is really, really key. As we're wrapping to the top of the hour, Dale, I'm wondering if there are other items or things that you want to make sure folks hear about today.
Sure. And if I could quickly go back to the North Dakota example, and I'm guessing in psychology, you all had, less than, 500 licensees. You're probably, so now
300.
the point of and the reason I bring that up is you may know most of the licensees or a lot of the licensees. And assuming if they were even educated in North Dakota, that may get even deeper. So you may know a lot of the respondents that might come before the board. And the question is what do you do? And, so you're going to go back to those principles we've already talked about. So let's do a little kind of overview and summary if we possibly can here to capture what the points we're trying to make today to you all as attendees. But you need to understand the principles that are at stake here. And you need to be in a position where you can contemplate, identify, seek advice, reflect upon that advice, and act. I've said that a lot, but let's just keep saying that. But you have to understand again that the concept itself. There's no bright line test. There's no place where you can go and just find the answer and say, "Bam, here's what I do." It's just not going to be that simple. But as Margot said, I kind of like the saying, "It's simple, but it's not easy." I mean, and that's probably a good reflection of that. So you have to take into consideration optics and the perceived issue, perceived conflicts. You might be accused of things you didn't even think of. And we all have to, one, understand those concepts, but two is we have to be prepared to defend ourselves as necessary. And how do we do that? And we do that by being an informed board member itself. Um, and kind of the last point I want to make to wrap all this up. And by the way, we talked about before I get to that, we talked about recusal, and I want to differentiate that from abstention. Recusal is you remove yourself from the proceedings. You don't participate, discussion, nor debate. You don't vote, and theoretically, you've left the room. Abstention is you might participate in the debate and the discussions and then just choose not to vote. You may say, I don't have enough information. I'm not prepared to do it, whatever. I think there are very few times where I think abstention is warranted, but I could see it potentially coming up. But understand those differences. But the bottom line of all this is that we all have to remember that your government, we're dealing with a government credential, a license that's being issued. We're dealing with a mandate to have that license. I must be licensed to lawfully engage in the practice of physical therapy or as a physical therapy assistant. And there are consequences to noncompliance, which, by the way, can include criminal sanctions. So a government credential, mandated, criteria are set forth in law. There are consequences to noncompliance, creates a property interest in that license, and that triggers what is called due process. And the whole reason we had today's discussion is because due process can be broken down as simple as a right to notice, a right to be heard. And by the way, be heard doesn't always mean verbally. It could potentially only be in writing, but a right to notice, a right to be heard, and a fair and impartial decision-making body. And that's where today's focus is. Can you be fair and impartial in your decision-making? Those in positions of conflict threaten that third prong of due process, threatens to due process, then threatens the ultimate overall decision-making of that board itself. And it may be subject to an appeal, and it may be subject to a lot of fancy legal arguments that can be made, but that does thwart the effectiveness of your board. So being informed about it, understanding the concepts, being able to identify the issues, seek that advice, reflect upon it, and then act are just absolutely critical. But I also want to say is the sky is not falling. Conflicts exist. They can be managed and dealt with. And do not be intimidated by lawyers who want to make those arguments and intimidate you in a manner where you might be asked to, or you might question whether you actually can be objective. There's so many examples that exist out there, including if I'm a respondent, complaints filed, I'm under investigation, I feel like I've been wrong, so I file a lawsuit against the board and argue my constitutional rights are being violated. And then I turn right around and say, now the board is conflicted and it cannot determine my my ultimate matter. I mean, and that has happened. But I myself, as the respondent, can't create the conflict necessarily and have that be successful. That doesn't work, but it helps us all understand and illustrate the points that need to be made. So with all that said, and Dave and Jeff, we'll turn this back over to you. But Margo, before I turn it back to you for any final quick comment you want to make, I do want to say one, thanks for having us. I'm hoping this format was enjoyable for you all, and there was some learning that came out of it. If anybody has any comments about that, please feel free to make those to Jeff, and so we can make sure that future webinars are fitting your needs. The other point I want to make is if you have topics that you think are relevant, please send those to Jeff and we can work those into future webinars as well. But a big shout out, thanks Dave to you and the board of directors, Jeff to you and the staff, and each and every one of you as a regulator for such an important role you play. Again, thanks for having us. So Margo, I'll give you the last word and then we'll turn it back over to Dave and Jeff.
All right. Well, I think the last thing I would say is just wrapping up and bringing this conversation to your next board agenda, either as a conflicts check, as a conflicts education time, and really rising that up to be something you feel you can have some confident conversations about and not shy away from. So again, thank you for all of the things that you are doing to serve the public, and thanks for letting us be here.
And I can't help myself now because Margaret just triggered another point, and that is a conflicts check should be undertaken at the start of every board meeting, so known conflicts can be identified into the record. But at the same time, depending on how often you meet, you should probably have a refresher on conflicts a couple times a year. Get your lawyer, your attorney in there and have them help you identify this. Go through a little exercise. It doesn't take that long, but it keeps a reminder going for purposes of conflicts and the importance that it carries. So sorry about that. So Dave
We
and
do have a quick
Jeff.
question too. Can we
Oh,
get that in, Dave? Okay. The
Yep, I
question
think go ahead, grab that. Yep.
is, what should a board member do if they've been exposed to comments made by a member who recuses themselves? Do I also now have to recuse myself? And wow, great question. This also happens when respondents might call you at your office and not the board office. So go ahead and answer that one, Dale.
if we can stall for 3 minutes, we could just end the meeting here because that's a difficult question. So the question here is somebody talks to me and identifies or provides information to me that may or may not be accurate, may or may not be admissible, and now am I tainted by that board member? And I think under certain circumstances, the answer might be yes to that. So the lesson to be learned by this question, in our short period of time here to answer it, is once a board member calls you, the very first thing is we can't talk about this. So stop. Let's get it on the agenda. Let's get the lawyer involved, whatever it takes to make sure you get the answers you need. But don't stay on the line and let this get so far where this question does become relevant. But if you do get this far and it does become relevant, I could see a plausible argument to be made that you now, as a recipient of that information, are conflicted. But that just is going to depend upon a lot of circumstances. So, but thank you. That's a really great point. And as you can see, we could probably think of really quite a few questions that would be relevant. But Dave and Jeff, we will turn it back to you. Margo, thank you so much for having me on your podcast.
And Dale, Margo, I really want to thank you for that interactive conversation and coming up with some of the different examples. I think, like you said, the adult learning, if you have an opportunity to put some of that content into actual context of what people see on a day-to-day basis in their boards. And I really want to appreciate and recognize the people that are participating too today. And the questions that they asked were very good questions and really thought-provoking, as you can see. So thank you again, Dale and Margo. Appreciate it. I do want to make sure people are aware of some upcoming regulatory events. And so the first one of those is our regulatory workshop. So April 9th through the 11th. Well, that's in Alexandria, Virginia, or it's a virtual too. We do have a few seats left. I really want to promote the regulatory workshop. It was one of the first things that I went to when I came onto the board of directors for FSBPT. It provides a great understanding of what you do as a regulator, what your role is, and then what the resources are within FSBPT. And so if there's a way to participate for that for you, either in person, again, we just have a few seats left, so you can go ahead and submit your registration, or if you can do that virtually, really highly recommend that. And then just our um, uh, uh, regulatory webinars that we have coming up. March 17th will be with Jennifer Simcoe. April 21st will be with Dale again. He'll be back on statutory interpretation. And then May 12th are some of the upcoming ones with Paul Welk. Each one of those is 4 o'clock Eastern time. And again, thank you all for what you do for protection of the public and meeting that mission on a day-to-day basis as regulators, and hope to see you at an upcoming FSBPT event or webinar. And again, thanks so much for all that you do. Take care, everybody.